In Western Australia, complaints regarding allegations of unlawful discrimination are handled by the Equal Opportunity Commission. The Equal Opportunity Commission is established under the Equal Opportunity Act, and its functions include to investigate, research and inquire into unlawful discrimination. The Commission aims to resolve complaints through a process of conciliation. The Equal Opportunity Commission can refer a complaint to the State Administrative Tribunal. So how does the complaint process work in Western Australia? To lodge a complaint with the Equal Opportunity Commission, a complainant may submit a complaint form online or via email or post. If the complainant does not wish to write their complaint, they may call the Equal Opportunity Commission to discuss it verbally. Complaints can be lodged in a language other than English, and the Equal Opportunity Commission will arrange for translation. The onus of proof lies with the complainant, and any supporting documents should be submitted along with the complaint. Complaints must be lodged within 12 months of when the incident took place. If a complaint is lodged out of time, good reason will need to be shown as to why the complaint was not made earlier. The Equal Opportunity Commission has 21 days to respond to the complainant. The Commission will conduct an initial assessment of the complaint and then may start an investigation. The Equal Opportunity Commission may provide a copy of the complaint to the respondent, who is the organisation or individual who has allegedly been discriminatory. The respondent has an opportunity to respond to the complaint. The Equal Opportunity Commission may also seek further information such as dates, documents, CCTV, audio or video recordings, or witness statements. The Commission may then seek to conduct a conciliation conference to try to resolve the complaint. The Commission does not take sides and does not provide legal advice. The conciliation conference provides parties with the opportunity to discuss their views on the complaint and to see if a mutual resolution can be achieved. The discussions during conciliation are without prejudice to enable the parties to speak freely. The conciliation conference may be held face-to-face, by telephone or video conference. Complainants and respondents are entitled to appear at conciliation personally or by an agent, or may be represented by a solicitor or counsel by leave of the Commissioner. The Equal Opportunity Commission may decide to dismiss a complaint at any stage if it decides the complaint is misconceived, lacks substance, or is not unlawful. Complaints may be withdrawn by a complainant at any time and may also lapse if a complainant fails to maintain their claim. A complaint will be conciliated if all sides reach a satisfactory agreement about how to resolve the complaint. How are complaints referred to the State Administrative Tribunal? There are two pathways that a complaint may be referred to the SAT. Firstly, the Equal Opportunity Commission can refer a complaint to the SAT where it appears to have substance and attempts at conciliation have failed. This is known as Commissioner referred. Where a complaint is Commissioner referred, a complainant has the right to ask the Equal Opportunity Commission to assist them in presenting their case to the SAT if requested to do so by the complainant. Secondly, if the Equal Opportunity Commission dismisses a complaint, the complainant has 21 days to request the Equal Opportunity Commission for a referral to the SAT. This is known as complaint referred. What is the process at the State Administrative Tribunal? The Equal Opportunity Commission will submit a report on the matter along with their referral. Matters referred to the SAT may be resolved by mediation or by a hearing. The SAT will hold an inquiry into the complaint, and ultimately SAT may dismiss the complaint or find the complaint substantiated. Examples of outcomes available at the SAT include an award of damages up to $40,000, an order prohibiting the respondent from continuing or repeating the unlawful conduct, ordering the respondent to redress any loss or damage, making a declaration that an agreement made in contravention of the Act is void, or declining to take any further action in the matter. Generally, parties before the SAT bear their own costs, and it is very rare for SAT to issue costs orders. In the Commonwealth jurisdiction, complaints of unlawful discrimination can be lodged with the Australian Human Rights Commission. The Human Rights Commission has statutory power to receive, investigate and conciliate complaints of unlawful discrimination. The Human Rights Commission does not make a finding about what happened or whether someone broke the law, but rather aims to resolve complaints through conciliation. There may be appeal options from the Human Rights Commission to the Federal Court of Australia or the Federal Circuit Court and Family Court of Australia if a complaint cannot be resolved through the conciliation process. To lodge a complaint with the Human Rights Commission, the complaint must be in writing, may be lodged by a representative such as a trade union, and may be lodged as a class action where multiple members have complaints against the same person arising out of the same, similar or related circumstances, and there is a substantial common issue of law or fact. The Human Rights Commission will refer the complaint to its president, who must inquire into and attempt to settle the matter by conciliation. In making this inquiry, the President will not be bound by strict rules of evidence and technicalities and will expedite the matter as much as possible. Conciliation provides the complainant and respondent the opportunity to talk about the issues and try to resolve the matter themselves. Conciliation is a quick, cost-effective and efficient way of resolving disputes. In practice, conciliation may be run face-to-face, via telephone, or via the exchange of letters and conversations with the conciliator. The Human Rights Commission does not maintain a physical presence in WA, and therefore it is likely that complaints lodged from WA would not have the option of attending an in-person conciliation, but rather one held via teleconference. Anything a person says or does in conciliation cannot be used in court proceedings. The only exception to this is that the court can consider information about offers to resolve the complaint that have been rejected when deciding whether to award costs. The Human Rights Commission may dismiss a complaint that they consider to be trivial, vexatious, misconceived, or lacking in substance, and may terminate a complaint on the basis that it is not unlawful discrimination, it is out of the statutory timeframe, it has been dealt with by other proceedings, or proceeding with the inquiry is not warranted, another remedy is available, the complaint has already been dealt with, or that the subject matter of the complaint could be more effectively or conveniently dealt with by another statutory authority. Therefore, it is useful to think carefully about alternative remedies and government redress options prior to commencement of any federal complaint. If the complaint is resolved through conciliation, resolution is usually written up in a conciliation agreement. Examples of how complaints may be resolved include an apology or statement of regret, an agreement to introduce policies to prevent discrimination or provide anti-discrimination training in the workplace, reinstatement to a job, or financial settlement for monetary loss or injury to feelings.
If the complaint is unresolved, the complaint will be terminated. If the Human Rights Commission terminates a complaint, a termination notice with reasons for the decision will be issued. The complainant then has 60 days to make an application to the Federal Court of Australia or the Federal Circuit and Family Court of Australia. The Federal Circuit Court is generally less formal than the Federal Court, and there may be less time to wait before the matter is heard by a judge. Under Section 46 PO, subsection 4 of the Australian Human Rights Commission Act, if the court is satisfied that there has been unlawful discrimination by any respondent, the court may make such orders as it thinks fit. There is no jurisdictional limit on the damages that can be awarded in the federal courts. Generally, the parties bear their own legal costs. It is important that you carefully consider which jurisdiction is best suited to your client's matter. Under WA legislation, there is a limitation period of 12 months from when the alleged incident occurred. The time limit in the Australian Human Rights Commission varies depending on the particular area of discrimination, and you should check this carefully. The Equal Opportunity Commission and the State Administrative Tribunal are physically located in Western Australia, and therefore the complaint and hearing processes can be conducted in person. The EOC can also provide some assistance over the phone, but only to assist you with making a written complaint if you are unable to do so. The Australian Human Rights Commission is not physically located in Western Australia, and so conciliation is likely to occur via teleconference. The ease and informality of proceedings in the State Administrative Tribunal compared to the federal courts is another important consideration for a pro bono lawyer or an unrepresented complainant. For example, the drafting of pleadings in the federal jurisdiction is a far more onerous process. There is the potential for a higher amount of damages to be awarded under the federal jurisdiction. There is no jurisdictional limit on the damages that can be awarded in discrimination proceedings in the federal court and federal circuit and family court. The State Administrative Tribunal, however, can only award damages up to $40,000. It is very rare for the SAT to issue cost orders, whereas under the federal court systems, cost orders can be made. However, following the recent passage of the Australian Human Rights Commission Amendment Costs Protection Bill, cost orders now cannot be made in respect of sexual harassment cases. It is also important to note the different terms under state and federal legislation. For example, the Disability Discrimination Act refers to discrimination based on disability, whereas the Equal Opportunity Act refers to impairment. The Sex Discrimination Act covers discrimination on the ground of gender identity, whereas the Equal Opportunity Act covers gender history.